Good evening, everyone, and thank you so much for coming up to the law school on what the news tells us is the hottest day in 2 years. It's wonderful to see people back in the law school. In the Ross Parsons Centre, we've been doing webinars over the last 3 years because of the pandemic, and we're slowly making the transition back to in-person. For those of you who might have been watching some of our recorded webinars, we will continue with those webinars. We'll be running those throughout the year. But we are also looking forward to having more in-person events. It's wonderful to have people back in the law school. The topic for tonight is the development of the common law by analogy to statute, and I'm delighted that we have 3 alumni from the law school to speak with you this evening. Our first speaker will be Adam Waldman, who's the Colin Fegan Associate Lecturer here in the law school. Adam's also doing a PhD here in the law school, which is fantastic. He'll be joined by Michael Vozdenovic, who's a lawyer at Herbert Smith Freehills, and he's also an adjunct senior lecturer here in the law school and a graduate of this law school. So welcome back.
Great. Thank you, Jason, and a special thank you for setting this up. And indeed, Jason did mention that he's my lead PhD supervisor, so he's been influential in some of the stuff I'll be talking about tonight. This evening, Michael and I are going to be speaking to a paper of ours in development, which is entitled The Development of the Common Law by Analogy to Statute. And what I mean by this is the idea that a court can look at legislation, construe it to discern something that is kind of broader than the direct effect of its words, and then take that kind of underlying notion and use it to inform the way in which it either develops or applies the common law in a given case. And the question that we're seeking to address is essentially quite a narrow one. It's just, is this legitimate? Is this a thing courts can do? Can they take an idea in a statute, even where it doesn't apply, and use that idea to shape the way in which they apply and develop the common law? So I'll be talking to the first 2 parts of our paper, which concern background and the Australian jurisprudence, looking at what the High Court has kind of said and done on this form of judicial reasoning. And then Michael is going to talk through the third part of our paper, which is a really interesting section he's developed out of some research that he was doing during his master's at Columbia in New York City on what the United States has to say about this form of jurisprudence and whether we can learn anything from that. And then he's also going to wrap up. Just bear with me if I can see if I can get this slide. Very good. So in the first part of our paper, what I want to do is just think about how attitudes towards the relationship between the common law and statute have changed, and how this in turn has paved the way for recognizing the idea that the common law can develop by reference to statute. So our starting point in terms of that relationship between statute and the common law can be traced all the way back to kind of the early great common lawyers such as Edward Coke. He described statutes as an interference with the perfection of reason of the common law, and he may have even purported to have a power to read down the effect of legislation if it was contrary to what he considered fundamental principles of the common law, or based in what we'd probably call natural law ideas now. Now, obviously that kind of extreme view is not palatable today, right? It's precluded by what we'd now call parliamentary sovereignty, by the attitude which we have towards the legislature and the respect which the courts have to give to enactments of parliament. But what I want to suggest is that the general attitude encapsulated in that traditional historical view, it persists, and it persists in the way in which we view statutes negatively. Professor Burrows, as he then was, kind of put it really nicely. He said, cases are fun, statutes are perceived to be dull, dry, and difficult. And I think this is something, and certainly for those of you who are practitioners in the room, it's certainly only been exacerbated in recent decades. Statutes are growing longer, statutes are growing more complicated, and the scope of statute is expanding to areas which previously kind of the sole domain of the common law. This kind of idea and the way in which it's tied into those negative attitudes is really well captured by the quite colourful phrasing of a couple of American commentators. Guido Calabresi said that we are choking on statutes. Professor Grant Gilmore described the period that was the early to mid 20th century in the United States as one that was an orgy of statute making. And I think these kind of ideas that statutes are everywhere, and also to some extent that we kind of don't like them, those definitely resonate with a lot of Australian practitioners and academics. In terms of the importance of this, I think it's easy to kind of say, well, this is just an attitude. We don't like statutes. We don't want to deal with them. It's kind of a benign, unimportant thing. What I want to suggest is that's not the case. And that's because when we view statutes with antipathy as these things that we don't want to deal with, what we're doing is becoming resistant to the kind of broader and subtler effects that they may have on the influence and on the development of common law. Now, certainly since the early 20th century, we've seen a shift away from these attitudes, away from what Sir Jack Beatson summarised as the oil and water view, that statute and the common law may interact, but that they can't influence each other, that these two separate things that don't fully mingle. And we've seen this shift away from kind of the beginning of the 1900s, and especially in the last couple of decades in Anglo-Australian law. And I want to suggest the kind of largest reason for this is because of these ideas that have been developed in a body of literature that shows that that historical oil and water view is wrong. And also not just that it's wrong, but that it's anti-historical, that it has always been the case that statute and the common law have had quite a significant influence on the content of each other. This literature began with a really influential paper by Professor Roscoe Pound in 1908, published in the Harvard Law Review. And then it was developed further in the United States. And since around the 1970s, it was kind of picked up in Australia and England. And I should note that the kind of really influential early works in Australia were those of Professor Finn and those of Professor Gummo, who I'm delighted to have here tonight. Now, I could talk to these ideas and why they show that statute and the common law intermingle all night. I won't put you through that kind of, well, maybe not torture for me, but torture for you perhaps. What I do want to do is just kind of summarize a couple of the key themes that come out of them and argue that the kind of key idea that I want to emphasize that comes from this body of literature is that statute and the common law are not these kind of two things that we can really clearly separate. There's no really strong, clear delineation between what we call statute on the one hand and common law on the other. But rather the line between them can be quite blurry, and as such, that it's quite natural that one might affect the content of the other. So the first idea that I want to talk about, which I've got up on the slide, is essentially just that much of what we now call common law actually had its origins in statutes or in responses to statutes. One way in which we see this are those kind of principles or doctrines which developed in response to statutes, basically to get around them or to circumnavigate them, but that continue to exist, and we characterize them as kind of being common law or general law doctrines. And the classic examples here are from equity, the doctrine of part performance, which essentially only makes sense as a doctrine that tries to get around statutory requirements contained in what was then the statute of frauds. And of course, the more general and significant doctrine of equity, which is the trust itself, the trust only developed as a way of kind of getting around the statute of uses of 1535. What we also see, though, is we see this idea that what we call common law once had origins in statute. In cases where the common law takes something that originated in statute and it doesn't subvert it, but it actually kind of picks up and runs with it and develops it further. And a good example of this is that the distinction between manslaughter and murder in criminal law was something that the common law took from statute and developed and kind of gave its own life. And then interestingly, now in contemporary Australian law, it's been partially codified back in statute again. So that's kind of the first idea, that there's no clear delineation between statute on the one hand, common law on the other. The second idea that I want to pick out is this idea that the method by which we give meaning to what is statute is itself one that's really heavily informed by the common law. We see this in kind of the narrow and perhaps the more obvious sense, which is that the principles of statutory interpretation themselves originated as common law principles. The other way in which we see this, though, is in this kind of broader sense, which is that the common law doctrine of precedent can have a really strong influence on the way in which we interpret statutes, and particularly in what some of his writings, Justice Leeming has called open-textured statutes, such as the kind of broad prohibition on misleading or deceptive conduct in Section 18 of the Australian Consumer Law. Now, that prohibition, it's clearly given force by way of statute. But if we want to say, what does it mean to say something is misleading or deceptive, then we have to go to this quite substantial body of case law that says, this is what it means here and this is what it means there. And the question that kind of gives rise to is, well, what do we call that body of case law? Is it statute? Is it common law? And the answer that I want to suggest is it's not so much that it matters. It's more just that it perfectly demonstrates the way in which the common law informs the meaning of statute, and then kind of further demonstrates that there's this blurry line between what we call statute and what we call common law. The last idea that I'll pick out of this literature is just this broader way in which all statutes rely on what Burroughs has called the infrastructure of the common law. So one way in which we see this is where we have legislation that adopts common law terminology, and then the meaning of that legislation is quite heavily informed by the common law idea. So a great example here is the prohibition on unconscionable conduct in section 21 of the Australian Consumer Law. The courts here have said, well, what this means is a question of construction, but that question of construction is quite heavily informed by the meaning of unconscionability and equity. Another way in which we see this idea that statute relies on the infrastructure of the common law is where we have legislation that takes existing common law or equitable duties and makes specific alterations to them. So a good example here is the Trustee Act, which starts with the baseline trustees owe certain general law duties to beneficiaries. And then what it does is it essentially goes in and it alters the content of some of them. It makes some of them narrower. It makes some of them broader. Some of them it gets rid of altogether. And the ultimate point that all of these kind of ideas get at is just that statute and the common law have a really strong interrelationship, but also that they always have had a really strong interrelationship. And this is summed up in what Chief Justice Gleeson said in the case of Brodie and Singletonshire Council, which I've got up there on the slide. His Honour said, legislation and the common law are not separate and independent sources of law, the one the concern of parliaments and the other the concern of courts. They exist in a symbiotic relationship. And this is what Michael and I argue represents the modern view of the relationship between statute and the common law. Not that they're like oil and water, but in fact the opposite of that they are symbiotic and that they always have been. Now, recognizing this leads to the next question that I want to address today, which is, in light of this really strong interrelationship, is it legitimate for the common law to develop by reference to the ideas that are kind of underlying within statutes? Now, when it comes to the Australian jurisprudence on whether or not we can develop the common law by reference to statute, perhaps unfortunately, the first thing that I have to admit is that there's a really strong divergence between what the High Court has said about the legitimacy of this form of reasoning and then what the High Court has actually done when it comes to applying this form of reasoning. So to start with the discussion by the High Court of analogical reasoning to statute, or in other words, what the High Court has said, there are only two really significant leading cases where this reasoning has been discussed as part of the ratio decidendi of the High Court's decisions. The first is the case of Lamb and Cotogno of 1987. The issue in that case was whether exemplary damages were available in a claim for trespass in circumstances where New South Wales legislation had shifted liability from the defendant who was a driver to a compulsory third-party insurer. And the court here held that exemplary damages were still available, despite the fact that they'd be payable by the third-party insurer rather than by the defendant. And in the course of doing so, the unanimous judgment of the court discussed this idea of whether we can develop the common law by reference to statute. The discussion is quite short. It's at pages 11 to 12 of the Commonwealth Law Reports. So what I might do is just kind of read a really key passage from the judgment. Their Honour said, even if it were possible for a court to go beyond what a statute actually enacts and to draw from it some principle to be applied by way of analogy in fashioning the common law, it would not assist the defendant's argument in this case. Such an approach was first suggested by Pound in 1907, but it has never really gained general acceptance, at all events in that simple form. And then they went on to apply that to the facts. So they said, in this case, there is no principle or trend to be discerned in the New South Wales statute or any other legislation concerning the measure of damages to be applied in cases of compulsory insurance. And thus they concluded that exemplary damages remained available despite the fact that the statute had shifted them away from the defendant towards a compulsory third-party insurer, and thus perhaps undermined the purpose of granting them. Now, to make a quick comment before we move on to the next case about Lamb and Cotogno, I just want to emphasize here that it's undoubtedly the case. The High Court is clearly very skeptical, and you can tell from that passage, of the idea that we can develop the common law by reference to statute in this case at that time. What I do want to suggest, though, is that it's important to bear in mind that they do leave it open. Their wording is even if it were possible. So they don't ultimately say this is not a thing that we can do here. That then brings me to the next leading case on this form of reasoning, ESO Australia and the Federal Commissioner of Taxation. The issue here was that the Evidence Acts, which at that time had only been enacted by the Commonwealth Parliament and the New South Wales Parliament, had changed the test for legal professional privilege from what was once a sole purpose test to what was then a dominant purpose test. And the question that came before the court was whether the common law test, in circumstances when neither of those pieces of legislation applied, should the common law test itself develop away from a sole purpose and towards a dominant purpose test. Now, the majority judgment in ESO and the Federal Commissioner of Taxation, they discussed analogical reasoning to statute at much greater length than was the case at Lamb and Cotogno. And again, in this case, they didn't resolve the legitimacy. There was no clear statement, this is a thing that courts can do. There was also no clear statement, this is not a thing courts can do. What they did say, though, is this. They said that on the facts, the common law test could not develop by reference to the Evidence Acts because those Evidence Acts only applied in 2 jurisdictions, and it would be inappropriate for legislation only from New South Wales and the Commonwealth to affect what was the one common law of Australia. Interestingly, though, the outcome was that they actually did change the common law test anyway. So the test after that case at common law did shift from sole purpose to dominant purpose. I want to suggest the reasons for that were essentially the reasons that courts normally change the common law and develop the common law, which is that they essentially looked at a whole bunch of different reasons and said, we think the dominant purpose test is better and it's open to us to change to it, and so we're going to do that. Now, there's a couple things I want to say about this case in a bit more detail. The first is that once again, they leave the legitimacy of the reasoning open, but you'll see if you look at the judgment, and particularly in the paragraphs where they discuss it in detail at paragraphs 20 to 28, I think it is, the court is much less skeptical of this form of reasoning in the abstract. Then the second thing I want to talk to that comes out of the ESO case is just this question of, well, can the common law only develop following ESO if legislation applies across every single Australian jurisdiction? Because at first glance, that's certainly what this case seems to suggest. But what I want to argue is that when you look at it a little bit closer, that's actually quite a problematic interpretation of the ESO case, because later in the judgment, when the majority are articulating the various reasons in favour of reformulating the common law test to be consistent with the statutes, one of the things that they say is, well, New South Wales and the Commonwealth Parliaments have adopted this test of those in their Evidence Acts. And so how do we reconcile this inconsistency where the court earlier in the judgment says it's not appropriate in this case, and then later in the judgment, they cite that very thing as one of many reasons in favour of changing the common law? The argument that Michael and I make in our paper is that the best way to reconcile this idea within the case is to say that if legislation doesn't apply across every Australian jurisdiction, then the common law has to be cautious in developing by reference to it, but it can still develop by analogy to it if it is otherwise appropriate. And there's a few reasons that we argue this. It's because we think that kind of best reflects what the High Court actually did do in this case. They did draw on those Evidence Acts, but they certainly seem to express some caution at doing so. Another reason is it's entirely consistent with how other federal jurisdictions have dealt with this, and Michael will talk to that in the section on the US jurisprudence. The last reason, though, is because kind of our view is consistent with what I want to suggest is the very nature of common law reasoning, which is that the common law draws on convincing reasoning and ideas, whatever its source. One American commentator has said that the common law is a great snapper up of ideas. And essentially, it seems really weird to me that the common law could develop by reference to an idea contained in an article essentially written by anyone, published anywhere. It could develop by reference to ideas contained within international law, but it couldn't develop by reference to an idea that is contained within a statute enacted by an Australian Parliament. Now, that then brings me to kind of the end of this discussion by the High Court section. The last thing I just kind of want to briefly flag is this. Following ESO, there have been several cases which contain either obiter dicta or statements in dissenting judgments, which are much more openly in favour of analogical reasoning. And certainly if you kind of buy into looking at the tone of the High Court over time, they seem to suggest that we're moving a little bit towards less scepticism of this form of reasoning. So where that leaves us then is that at first glance, if you look at these leading cases, they seem to cast doubt on the idea that you can develop the common law by reference to statute. But when we really dig in and pick them apart a little bit more closely, what we think they suggest is that at worst, this is an unsettled issue. And at best, there are quite strong indications that this can be legitimate in appropriate cases. And that then brings me to the last thing that I'm going to talk about, which is the usage of analogical reasoning to statute by the High Court, or what the High Court has actually done when it comes to this form of judicial reasoning. And my argument is that by contrast to the cases where the High Court has discussed this form of reasoning that we've just talked about, we can actually identify cases that span decades and quite diverse areas of law where the High Court has developed the common law by reference to underlying ideas within statute. And so our ultimate argument is that when you consider these cases together with the cases where the High Court has left the reasoning open, the correct view has to be that it is already legitimate for Australian courts to develop the common law by reference to statute. So let me talk through a couple of these cases in the 5 or so minutes I have left. The first case is the decision of Justice Dixon in Cohen and Cohen in 1929, in which His Honour recognised that certain equitable remedies that fell outside of the statute of limitations were nonetheless barred by analogy to that statute. I'm going to quote him at pages 99 to 100. He says, "The statute of limitations by its terms does not operate directly upon equitable remedies, but such remedies are barred in courts of equity by analogy to the statute." So this is the first case that we've identified where the High Court quite clearly does develop the common law, or more specifically equity by reference to statute. It's also quite a good example because it's pretty clear cut that what Justice Dixon is doing here is he's not applying the statute as a question of construction. He says the statute does not apply, but such remedies are barred in courts of equity by analogy to the statute. The next case I want to talk about is the Crown against L from 1991. And the question for the High Court here was whether marriage constituted irrevocable consent from a wife to a husband for sexual intercourse at common law. And the High Court said no, that it did not. But importantly for our purposes, the majority judgment of Chief Justice Mason and Justices Dean and Toohey said that even if the common law ever did recognise marriage as being irrevocable consent, it didn't do so any longer. And their reason for that, or one of their reasons for that, was that they drew on legislation which applied across every single Australian jurisdiction that criminalised rape within marriage. And that was then cited as a reason against marital rape being lawful at common law. And so I think one of the reasons I find this to be a particularly interesting example is because, well, A, those statutes clearly reflect changing social policies and societal values, but B, what's interesting here is that the influence of the statute is just one of several different reasons why the common law developed in that way. So the third case I'll talk through is the case of Crimmins and Stevedoring Industry Finance Committee, a judgment of 1999. And the question for the High Court here was whether a statutory body that was responsible for allocating workers to particular stevedores owed a duty of care at common law and negligence to an individual stevedore. Now, the High Court here said yes, and what I want to pick out is that in both the judgments of Justice McHugh and the judgments of Justice Kirby, both of their honours said that the legislative purpose of the legislation that established that statutory body was one of fostering safety. And as a result, they said that was a reason in favour of imposing a duty of care from that statutory body to the individual. And so again, this is quite an interesting example where the underlying idea within the statute is one of many different reasons that leads to the way in which a common law duty of care is applied on the facts. Finally, the last case I'll talk through is a much more recent decision of Smethurst and the Commissioner of Police. And the facts here were that the Australian Federal Police seized data which it put on a USB from a journalist under a search warrant that turned out to be invalid. And as a result, the seizure was unlawful and a result of a trespass. And the question that we're concerned with is whether or not an injunction was available requiring the police to either destroy the data on the USB or to give that USB with the data back to the journalist and her employer. And the High Court split 4-3 here, and they ultimately said no, an injunction was not available. But what I want to pick out from this case is that in both one of the majority judgments and one of the minority judgments, we can see that analogical reasoning to statute was used to support the various conclusions. So in the judgment of Chief Justice Kiefel and Justices Bell and Keane, their honours noted that the Evidence Act permitted the use of unlawfully obtained evidence, even though it didn't, there wasn't any question of the Act applying to those proceedings. And they then took this into account in deciding that it was appropriate not to grant an injunction. And then by contrast, in the dissenting judgment of Justice Edelman, his honour noted that the Crimes Act imposed requirements on the ways in which you have to handle lawfully seized data, but that the Crimes Act did not apply because the evidence in this case was seized unlawfully. And he said, well, this was another reason in favour of showing that damages were not an adequate remedy, and thus that an injunction was available. So a really interesting example, both because it's quite recent, but also because we see the use of this form of reasoning by the majority and the minority judgments in support of their respective and different conclusions, and also because they draw on the underlying ideas contained within two different statutes, neither of which actually applied on the facts in terms of supporting their conclusion concerning the equitable remedy there. Now, just before I wrap up and hand over to Michael, I'll flag that in our paper, which is forthcoming, we have a bunch more examples. These are just some ones I've tried to pick out. What I do want to emphasize just to conclude is that when we consider these cases where the High Court has clearly used such reasoning, and we consider them next to the cases where the High Court has said maybe this reasoning is legitimate, the better view has to be that it is legitimate for Australian courts to develop the common law by reference to statute. So I'll hand over to Michael now to talk about the US jurisprudence on this really interesting topic, and then to wrap up and conclude for us.
Thank you very much, Adam. So turning then from the Australian jurisprudence to the US jurisprudence. So as Adam flagged, the US law has long accepted analogical reasoning to statute as a very legitimate form of judicial reasoning. I have only about 5 minutes to summarize about 2 centuries worth of jurisprudence, but I'll do my very best. So perhaps the best starting point is to consider a judgment of Justice Holmes. As some of you may know, Oliver Wendell Holmes is very much a celebrated figure in US legal history, very much the Lord Denning of his day. You can see there in the very first citation, a decision of the US Supreme Court in 1922. But to understand that case, it's necessary to go back to an earlier decision of His Honour when he was sitting on the High Court, but albeit writing as a circuit judge in 1908 in the decision of Johnson and the United States. I'm going to briefly skip over the facts for now. Probably the most relevant part is his seminal reasoning later in the judgment, where he says, quote, "We quite agree that vague arguments as to the spirit of a statute have little worth. We recognise that courts have been disinclined to extend statutes modifying the common law beyond the direct operation of the words used, and at times this disinclination has been carried very far. But it seems to us that there may be statutes that need a different treatment. The major premise of the conclusion expressed in the statute, the change of policy that induces the enactment, may not be set out in terms, but it is not an adequate discharge of duty for courts to say, we see what you are doing, but you have not said it, and therefore we shall go on as before. In other words, courts should be looking to the underlying value present within the statute, and if appropriate, using it to develop the common law." Just as an aside, that passage from Johnson and the United States continues to be cited to this day. It's not been overruled and was cited even as recently in a 2020 US Supreme Court decision of McGirt and Oklahoma, a decision of Chief Justice Roberts, with whom Alito, Kavanaugh, and Thomas agreed. I only mention the relevant judges there because when we're talking about the legitimacy of analogical reasoning to statute, again, there is a debate in the US between judicial activism and judicial restraint. But here you have a very strong conservative bench of the US Supreme Court accepting that this form of legal reasoning is legitimate and can be used in appropriate cases. But jumping back in time, so after Oliver Wendell Holmes is elevated to the bench of the Supreme Court, his reasoning is quickly adopted by various others, learned jurists of the bench, most notably Justice Cardozo, again, a very celebrated figure in US legal history. In that judgment quoted there on the slide, His Honour said, quote, "Legislative policy is itself a source of law. a new generative impulse transmitted to the legal system. And as recently as 2018, that particular passage was quoted with approval by Chief Justice Alsop in the full federal court decision you can see there on the slide. Cardozo's Holmes' reasoning was also accepted and adopted by Justice Frankfurter, who observed that, quote, statutes, even as decisions, are not to be deemed self-enclosed instances. They are to be regarded as starting points of reasoning. And then fast forward about 40 years or so, you have perhaps the most seminal decision on this jurisprudence, which is Marine and States Marine Lines. It was a unanimous decision of the court, with Justice Harlan writing for the court, in which the decision pretty much removed any doubt that this form of legal reasoning is an accepted one and to be used by all courts, both federal and state in the US legal system. The question before the court in this case was whether a wrongful death action existed in maritime law. And importantly, just pausing there, maritime law is one of the few areas of law in which US federal courts exercise a common law jurisdiction. So it's not completely limited to statute. So in determining that such an action was available, the court expressly recognized that courts can and should engage in analogical reasoning to statute where appropriate. And the most relevant passage is quoted there on the slide, and I'll let you read that in your own time. Importantly, applying the reasoning quoted there to the relevant facts, the Supreme Court recognized the availability of a wrongful death action in the federal common law, including because, quote, every state today has enacted a wrongful death statute, which suggested that a rule against recovery for wrongful death would be, quote, sharply out of keeping with the policies of modern American maritime law. So in other words, this case firmly established that the development of the common law by analogy to statute has been a legitimate form of judicial reasoning since at least 1970. But as our paper argues, and as Adam mentioned in his part of the presentation, really this form of reasoning has been long accepted in US jurisprudence. Perhaps a reason for that is that the very early deans of various leading law schools all expounded this form of reasoning as legitimate and appropriate. So for example, Adam mentioned Roscoe Pound, who was the dean of Nebraska Law School and then subsequently Harvard Law School. You also had the dean, James McCallis Landis, who was later dean of Harvard Law School, a student of Justice Frankfurter, who I mentioned earlier, and a law clerk to Justice Brandeis. And then after them, Harlan Stone, who was a dean of Columbia Law School, and then later both a justice and a chief justice of the Supreme Court. So in other words, you had very leading and prominent figures in US legal history, all advocating for this approach as entirely legitimate. So accepting for present purposes that this form of reasoning is an entirely valid one, and indeed has been ongoing in US legal history for almost 2 centuries now, the question for us, perhaps more practically, is what lessons can be derived from that jurisprudence, i.e. what lessons can Australian courts learn when developing the common law by analogy to statute? In our paper, we suggest there are probably 3 key lessons that can be derived from that particular US jurisprudence. The first is an explicit discussion of the usage of analogical reasoning to statute. So as Adam mentioned, when Australian common law is developed by analogy to statute, albeit there are a few limited instances of this, in the instances where it has done so, it is common for there to be no discussion of the fact that such reasoning is being utilized. Justice Kirby in dissent in a High Court decision of Harrington and Stevens noted, quote, if courts are in fact relying on legislative policy as a reason for altering the course of the common law of torts, that reliance should be disclosed. Without such disclosure, the appropriateness of such reliance could never properly be considered and contested. His Honour was noting that if courts are really trying to develop the common law by analogy to statute, they should expressly say they're doing so that other members of the bench can consider, and really the whole legal community can consider what is actually taking place in forming that ratio decidendi. And perhaps the most stark contrast, and indeed it's this passage that was the inspiration for my research in the US, is a decision of the Mississippi Supreme Court in 1986, which is the first citation there on the slide. It's quite a long quote, but it's actually quite useful in demonstrating how open US courts are to openly discussing what they're doing. In that case, the Mississippi Supreme Court said as follows: our decision to apply Section 2 by analogy is wholly in keeping with this court's proper role as an interstitial lawmaker, where our law of sales, and it was applying the Uniform Commercial Code in this case, still in the form of common law rules, we would not hesitate to extend them to situations functionally analogous to those which give rise to and fall within the coverage of those rules. Such is the nature of the common law process. That the rules are now in statutory form compels no change in process. the only alteration is in the materials employed as the basis of deliberation and adjudication. Instead of precedent and case law analogies, the statutes are available. The statutory rules, like the former common law rules, remain only points of departure, only analogies, although exceptionally informative and persuasive and illuminating. So in other words, US courts at both a federal and a state level, this being probably the first state citation we've given, strongly indicate that there is a benefit to, when using analogical reasoning to statute, to openly say that you are doing so. So that's lesson number one. Lesson number two, which is something again that Adam briefly touched upon, is what are the relevant restrictions upon analogical reasoning to statute? So I should say at this point, this is a slight adjunct from what we were talking about, in the sense that the focus so far in this presentation has been on the legitimacy of this form of reasoning, i.e. can courts actually engage in this practice? But assuming for present purposes that courts can engage in such a methodology, are there any restrictions on doing so? And so the two cases where the High Court has expressly discussed this form of reasoning, which are those that Adam mentioned, seem to come up with two possible limitations. So in Lamb, it was suggested that there must be a trend in legislation that reflects a consistent policy, i.e. you have multiple statutes over time that seem to suggest a coherent or uniform direction as to how the legislation, i.e. Parliament, is viewing a particular issue. And if you can identify such a trend, then you can derive from that trend a particular policy or notion or theme, and then use that theme to develop the common law. In the seminal case of marine and state marine lines, which is the case referred to on the earlier slide, the Supreme Court of the United States rejected that notion as an absolute limitation. The court there said, quote, "In many cases, the scope of statute may reflect nothing more than the dimensions of the particular problem that came to the attention of the legislature, inviting the conclusion that the legislative policy is equally applicable to other situations in which the mischief is identical. This conclusion is reinforced where there exists, not one enactment, but a course of legislation dealing with a series of situations, and where the generality of the underlying principle is attested by the legislation of other jurisdictions." So entirely consistent with the approach that Adam and I advocate for, such a trend, i.e. a trend in policy in the legislation, is relevant only to demonstrating the existence or the scope of the underlying theme or principle, but it is not a strict requirement that should be imposed on courts in utilizing this form of reasoning. The other possible limitation identified by the High Court was that in Esso, which was the question of, does the relevant legislation need to apply across all Australian jurisdictions? So you'll recall from Adam's discussion that the High Court seemed particularly concerned about the fact that the Evidence Act at that time, the Uniform Evidence Act, had only been enacted at the Commonwealth level and in New South Wales before it had been extended to other states and territories. Again, perhaps unsurprisingly, US courts haven't viewed this as a strict requirement, i.e. there is no strict requirement that every particular state have adopted a particular piece of legislation or analogous legislation. Rather, again, it's just a factor that feeds into the court's thinking as to whether or not this form of reasoning can be used. At this point, it's also important to pause and note that there are differences, of course, here between the Australian and the US legal system, in the sense that Australia has one common law, whereas the US contains 50 coordinate but separate common law states, in addition to the limited federal common law that I mentioned earlier. Notwithstanding, that hasn't stopped US courts from applying this form of reasoning. So by way of example only, the Supreme Court in American Express Lines and Alves, a decision in 1980, developed the US federal common law by analogy to principles of state law, which was derived from both state common law and statutes, on the basis that such principles had been adopted by, quote, "a clear majority of 41 states and the District of Columbia." So two key takeaways from that particular decision. The first is that, again, unanimity is not required, albeit there was quite a large number of states in this instance, 41 out of 50. But also the cross-pollination was occurring between both a federal and a state level. You had a federal court using state legislation to develop federal common law. And again, that is entirely consistent with the view we advocate for in our paper, that whether or not legislation is consistent or applied across all jurisdictions is, again, just a relevant factor to consider. It is not a necessary requirement or prerequisite to engage in this form of reasoning. And the final point that we argue that Australian courts could learn from their US counterparts is just simply that this form of reasoning has been going on for a very long time. And so if there is any doubt as to whether or not it is a legitimate form of reasoning, Australian courts can simply look to their US counterparts to see that this has been going on for at least 2 centuries. As Adam mentioned, in Lamb and Cotogno, the High Court made reference to Pound's seminal paper all the way in 1908. In that paper, Pound expounded 4 possible avenues through which legislation could be incorporated into the common law. The first avenue is that statute should be immersed into the common law and courts should treat statute as superior to case law. The second avenue was the same, albeit it argued that statute and common law should be viewed on equal footing. The third was that statute should only be immersed into the common law, not by analogy to statute, but through liberal interpretation of the particular legislation. And the fourth avenue is even a stricter version, that you cannot integrate statute into the common law and only apply a strict and narrow interpretation of the statute with no possibility for analogical reasoning. So both jurists and academics have sought to identify where Australia, the UK, and the US fall in Pound's particular 4 categories. We advocate in our paper that Australia sits somewhere comfortably in the middle, the second category, that legislation and case law should be seen on an equal footing, and that statute can then be used to develop the common law by way of analogy. And I note only as an aside that in that same case, Jail, Teal and Co., the Mississippi Supreme Court suggested that statute is the superior of common law, which would seem to suggest that US state law may, in certain jurisdictions, fall within Pound's first avenue, i.e. that statute is to be considered the superior of common law. So before I hand over to Justice Leeming, the above slide just seeks to touch upon some other topics that we haven't had a chance to discuss today, but are equally important when we're discussing analogical reasoning to statute. The first heading there is the merits of this form of reasoning. Adam already mentioned a couple in his opening address, i.e. that courts should be free to draw upon various sources in developing the common law. So if they can use academic writing and if they can use foreign law to develop Australian law, why can't they use statutes, albeit they're not said so in express terms? Statutory principles reflect societal values identified by the legislature. That's been a theme picked up by many academics and courts, including boroughs, as Adam mentioned earlier. It would also foster greater coherence in the law. Again, this term coherence and this idea is particularly fashionable at the moment, given the High Court's recent emphasis in cases such as Miller and Equus Corp. And indeed, Professor Band has argued that analogical reasoning to statute would just be a subset of this broader notion of coherence, but certainly gives greater weight to it. And then the last point is perhaps the most important, which is that simply being able to develop the law by analogy to statute does not mean that courts will ever be required to do so. It's just another tool that they have to be able to develop the common law if a statute does not apply directly on its terms. And then the final dot point asks us to ponder, again, assuming we accept legitimacy of this form of reasoning, i.e. it can be used as a form of judicial methodology, then when is it appropriate to do so? How should statutes be used? And what are the limits, if any, in using statutes to develop the common law? So these 3 questions are fairly broad, and perhaps there is no one right answer to any of them. But the main thrust of our thesis and the presentation today has simply been tried to convince everyone in attendance here that this form of reasoning is a possible one, and courts should be more open when using it in their forms.
Yeah, so we might draw it to a close there. We will be having some refreshments outside. So if our speakers are able to hang around a little bit longer, maybe you can ask them a question. Otherwise, if you can join me in thanking our speakers for tonight. Thank you. And if I could just give a little plug to the next Ross Parsons event. It's the Ross Parsons Taxation Lecture, which my retiring colleague, Professor Graham Cooper, will be giving on Wednesday night. If you're interested, you can find details on the law school's website. And if you'd like to join us outside for refreshments.